If you are just joining us, welcome. My name is Brenda Neckbottle. I am also known as Brenda the HR Lady. Again, you can follow me over at brendathehrlady.com. And today we're going to be talking about, oops, I almost goofed up here. Today we're going to be talking about a couple of topics. One of the main topics that we're going to be talking about is really why details matter and how the courts rule. And this is important for you guys to know. And the reason why I get into this is because if you don't understand how these things work, you're already operating as government contractors in an environment with a stringent level of compliance. You have to go a little bit deeper, get into the details to really understand why things are, so that way you can get the people side of your business right, because that's going to be critical to moving forward. Steve is a government contractor. You've managed like what, $147 million in contracts, I think, if I remember correctly. Okay. Yeah, at the minimum. So the fish gets bigger every time we say it, right? Uh, so, um, you know, so getting into the details, right? Steve's a government contractor. I'm a government contractor. We play in this, and actually, I've been just simply playing in the HR compliance arena since 2011. So understanding why things are the way they are in the government contracting world is so critical, just because there's more attention being paid to the compliance side of it. All right. So here's why the details matter and how the courts actually rule. Now, here's something that came out of a little blurb from a blog that I read. Fortunately, I didn't bother to catch the name of the blog, but anyway, the NLRB actually held that employees were lawful to keep instructions to keep an investigative interview confidential. All right. Now, normally when a ruling had come out, oh gosh, it was a while ago, where you couldn't tell an employee to keep an interview or an investigation confidential. There's actually part of this ruling that stipulates you can, under certain circumstances, under one certain circumstance. I'm going to explain this to you. Okay. So this was a little something that came out, which I found to be very interesting. And there's a lot of focus coming in on the National Labor Relations Board as well as the Department of Labor. This administration is moving forward to making our employment laws more employee friendly. Okay. And making sure that employee rights are being heard. Now, after receiving reports, this actually came out of a ruling called Alcoa Corporation 370 NLRB number 107, took place April 16th, 2021. So it's still very fresh. So after receiving reports that an employee made racist comments and subjected others to disrespectful treatment, the employer conducted employee interviews, telling each interviewee to keep the interview conversation confidential, including from supervisors and other employees. Now, under normal circumstances, that would not be allowed. But here's the reason as to why it is allowed. And this is something that clearly under this ruling you can do. Okay. And this is why paying attention to these details matter so much, and understanding how this stuff works. Based on the results in the investigation, the employer suspended the employee for 3 days pending further action, which is totally normal. Okay. And under the NLRB precedent, investigative confidentiality rules that by their terms apply only for the duration of the investigation are categorically lawful under what's called the Boeing Company framework. Now, let me help you understand what a Boeing Company framework is. All right. So applying what they just referred to as Boeing is what's called an administrative law judge. Okay. And what it is it finds the employer actually violated the National Labor Relations Act. All right. However, when and so what they violated supposedly was by issuing the I can't say it. It's like I have to slap myself in the back of the head. Confidentiality directive, because it on its face, on the surface, it wasn't limited to particular times or places. Now, here's where the reversal comes in. The reversal comes in because after the findings, it turns out that the instructions were therefore lawful. And the National Labor Relations Board held there was no evidence the directors were given pursuant to a general company policy or rule. That's number one. Or that they applied to anyone other than the employees interviewing during the specific investigation. So therefore, The NLRB found that employees would reasonably understand the confidentiality restriction was limited only to the duration of the investigation. So that's why understanding the details count, and understanding how courts, and in this case an ALJ, rules is the very last statement that I made. Employees would reasonably understand. So that's how courts rule in HR and under employment law. If and it's a if what would a reasonable person do? And that's going to be key and critical to anything that you do. The question will always be, what is reasonable and what will a reasonable person do? Okay. So let's move on to our next one that we're talking about today. So here's something that government contractors run into all the time. And I know Steve's bumped into it. I've bumped into it. And what we're referring to is like when a government contractor loses a contract, or they get like a cease and desist letter, and next thing you know, or an employee actually does something that they shouldn't do, and all of a sudden the government says, yep, that person is totally off the contract, we don't care, make it happen. And that puts a government contractor, a lot of the times what happens is that what we understand and what we hear is the person's no longer on the contract. So therefore, that means that the government eliminating them from the contract gives you a green light to go ahead and terminate. But in fact, you may be in a position as a government contractor to actually not move forward with the termination. You have to take that step back and say, okay, so what are our risks with this person, particularly under EEOC? Because if you believe that the at will doctrine, which means that, if an employee is operating under at will, it means that they can, the employee or the employer can actually, cease the relationship at any time with or without cause. Here's what's happening. The at will doctrine has lost its power for years, and now it's continuing to lose its power. And here's a really great article that came out of Littler Mendelson on Montana, and Montana making significant changes to state employment laws. All right. And in particular, what we're looking at is changes to the wrongful discharge from an employee act. All right. And this is the reason why you really need to understand, going again back into the details. And what they put into place is that the governor recently signed 3 bills that make significant changes to Montana's wrongful discharge from employment act, a Human's Right Act, and a Wage Protection Act. So I want to talk specifically about wrongful discharge from an employment act, because this totally aligns with what goes on with government contractors. Now, the changes to the wrongful discharge and employment act are significant and actually benefits employers. However, the amendments create the default probationary period during which an employee may be discharged without good cause, increase proof of requirement for wrongful discharge, and expand the source of income that are required to be subtracted from an employee's award, and simplify notice that employers must provide to an employee of their internal grievance procedure, which an employee must exhaust prior to filing a WEA claim. Okay. So that's there you go. And something I'm going to talk to you about in a little while is why it's important to not only follow what's going on at the federal level, but you have to focus in on at the state level. All right. So over in Montana, which we don't hear very much about at all, there's now a default probationary period that is extended. And under the amended WDEA, the default probation period is now extended to 12 months from 6 months after an employee's date of hire. When you look at the clarification of when an employer's violation of its policies constitutes wrongful discharge, an employer's voluntary violation of its written policies under the new amendment may result in wrongful discharge only when the employer materially violates its own written policies and the violation deprives the employee of a fair and reasonable opportunity to maintain employment with the employer. There's also definition of good cause that's expanded. And we talks also about broad discretion to terminate employees of managerial employees codified. All right. Also refers to broad discretion to terminate employee. Oh, sorry, reread that. Sources of income that may be deducted from an award expanded. So unemployment benefits received must be deducted from an award. And let me help you understand what I mean by award expanded. The act now requires that any award for wrongful discharge must include a deduction for any post-discharge compensation earned or that could have been earned from a new kind, nature, or type of work, among other things, provided that the employee was not receiving the compensation prior to the discharge. Now you're probably sitting here thinking like, oh, dude, that's only going on Montana. Yeah, it is only going on in Montana. But here's the thing. That's the point, is in an environment that we're working in right now, where you could be going after different types of federal contracts. You can have employees in Montana. You can have employees in a lot of different states. And the things about what's going on with the states is that we're seeing a real unprecedented change and increase in employment law, right? Rapidly changing, and it's in place to kind of address this new environment that we're in. But at will is constantly being challenged and constantly being diminished. And as you can clearly see, you have to be able to do your due diligence to ensure that if you're going to be terminating an employee because of a loss of contract, or that person is no longer permitted to work on the contract, if you just simply release them without doing your due diligence, understand what's going on, possibly even working with the government in Montana, you could probably have a really, really rough couple of months for wrongful termination, particularly if the employee actually didn't do what the government is accusing the employee of doing. That is not uncommon. It happens. And then there are times where the employee does exactly what the government says that they're doing. But nonetheless, even if an employee challenged something like that, and it turns out that, yes, in fact, the employee actually was guilty, lack of a better word, right? And actually did what they said that they were going to do, that's a lot of money going to attorneys for the conversations. That's money going in and labor spent working on the investigation. There's a lot of heartache. There's probably drama that's associated with it, right? So you really truly have to understand what it is that you're doing as far as at will prior to moving forward. Montana's a really great example of what that is. Now, a lot of folks are up against these questions around mandating vaccine requirements. Right. This is another really great example. And after we get done with this, I'm going to give you a resource on how you can stay up to speed with all the changes that are happening at the state level. So that way you're not caught off guard. All right. It's awesome. And I'll explain it to you in just a little bit. Now, here's another one coming out of Montana. Like, we never hear anything out of Montana, and all of a sudden, Montana has just become this blooming rose. All right. So this actually comes from a law firm called DLA Piper, and it's called U.S. Montana Prohibits Mandatory Vaccine Requirement, and more states are considering legislation. So this is where it gets really dodgy. And as you know, that there's a lot of people that want to mandate the vaccine, and there's a lot of risk in doing exactly that. But now we've got states that are actually prohibiting mandatory vaccine requirements for employers. And here's what we're talking about. So on May 7th, Montana Governor Greg Guyenfort, I think I said that right. If I didn't, I apologize to Montana, signed a law prohibiting most private and public employers from requiring employees to be vaccinated or show proof of vaccination as a condition of employment. Now, let me help you understand what a condition of employment is. And so condition of employment is exactly that. So a job description, assigned job description, is a condition of employment, meaning that here are the stipulations, here are the requirements of the job description. You either abide by it, or if you don't, you're not employed here, right? Pretty simple. Timekeeping is a condition of employment. All right. Your resume is not a condition of employment typically, but a job application is. An offer letter is a condition of employment. All right. So these are the things that actually back a person's legitimate employment within an organization. There's either some form of acceptance, but it's very, very clear, very clear expectations, right? Look at your timekeeping. If you don't show it, like a schedule, if you don't show up for work, you don't get paid. You don't show up for work, you no longer work here. Okay. It's a condition of employment. An I-9, however, is not a condition of employment. And the reason why an I-9 is not a condition of employment, it is not something that is agreed upon. It's actually a requirement that employers are to uphold to ensure that they actually comply with. Okay. And that all that is just confirming authorization to work in the United States. It's totally has everything to do with immigration, but it is not a condition of employment because uh, you don't have to be a citizen to work here in the United States. And that's not what the I-9 is doing. It just means authorization to work in the US. Okay. So, all right. So what they're trying to what some states are trying to do is vaccine as a condition of employment, or I shouldn't say states, but some employers are trying to do is create mandatory vaccination as a condition of employment. Now, specifically HB 702, which is the bill that was passed through, provides that with some expectation is an unlawful discriminatory practice for a person or a governmental entity to refuse, withhold from, or deny to a person any local or state services, goods, facilities, advantages, privileges, licensing, educational opportunities, healthcare access, or employment opportunities based on the person's vaccination status or whether the person has had an immunity passport. Now, immunity passports are going to be on the rise. Watch out for that. Okay. So I have yet to hear that the federal government is going to mandate vaccines, and there's a lot of pressure on the EEOC and OSHA to put out specific guidelines for vaccines to COVID, of which they have not yet done because the complexity, and they likely won't, because the complexity of laws prohibits, even under our own Civil Rights Act, to mandate vaccines broad spectrum, because there has to be carve outs and exceptions for religious and disability exemptions. Okay, so it's very complicated. Not to mention our infrastructure legally, as far as case law, there's a lot of that implanted in there. So that's not really something that can happen. All right. All right, next is going on. It also provides, with some exceptions, that it is an unlawful discriminatory practice for an employer to refuse employment to a person, to bar a person from employment, or to discriminate against a person in compensation or in a term, condition, or privilege of employment based on the person's vaccination status or whether the person has an immunity passport. Also, a public accommodation, it's unlawful if there's a public accommodation to exclude, limit, segregate, refuse, or serve, or otherwise discriminate against a person based on the person's vaccination status or whether the person has had an immunity passport as well. All other states or other states that have orders or new laws addressing vaccine requirements, here you go. You ready? If you're in this state, you're going to want to pay attention to this. Texas. Okay, there's an April 6th executive order that came out that prohibits the public and private entities from receiving public funds from requiring proof of vaccines or any COVID-19 vaccine administered under the emergency use authorization, which I can tell you right now, there's a court case over in New Mexico that we're watching that an employee at a corrections facility was the facility went through the whole mandated vaccine, had the policy, worked with the attorneys, everything on that part looked clear, but the employee went ahead and refused, was separated from the company, was terminated, filed a lawsuit under the emergency use authorization. And the EUA in the law, in the legal infrastructure, stipulates that if a vaccine or an inoculation is actually approved under the emergency use authorization, then it cannot be mandated legally. So that challenge is right now, we're waiting to get more information as to what's going on with that. It had absolutely nothing to do with employment. Okay, so similarly, also businesses in Florida are prohibited from requiring patrons or customers to provide any documentation certifying a COVID-19 vaccination or post-transmission recovery, and legislation would limit or prohibit an employer's ability to require employees to be vaccinated or disclose their vaccine status and or protect those who refuse vaccinations that is pending in more than a dozen states. All right, so I don't have the complete list, but that's where we're going with this. So understanding what's going on at the state level, here's why I want to give you this resource. If you go to brendathehrlady.com, you click on HR resources at the top. That's going to get you into our HR resource site, I should say. That's going to get you an offer to join a resource to where we have over literally 100 articles coming in at any point in time from 70 resources across the United States, including various states, and one resource coming in from Canada. We have almost all of the states covered. Okay. This is how you stay on top of what's going on. All right. You, uh, if you read and apply everything, even if you just glean over the titles, the headlines, this will give you an opportunity to really understand what is going on. In addition to that, not only do what we read as adults, and I know Steve with his background can certainly attest to this, when what we read as an adults, it has to be relevant, right? So if you're reading information that keeps you in the good graces of things, it's relevant, then you get to figure out how to apply it. All right. It's what you need to do to continuously learn. And government contracting, HR compliance in general, now you marry the two together, you really need to have a continuously learning attitude and a continuously learning mindset. If you don't, you're going to wind up running into something that you didn't anticipate. So that's how you do the hard well, right? Is you stay on top of things, and then when the hard starts coming up, then you get to take what you've learned. You at least know that something is out there. You actually know how to go about and finding it because you remembered it, or it came up. It's like, oh yeah, I forgot about that. And then you start Googling it. You already know what keywords to use, right? And so this site actually provides 6 major employment news categories: COVID updates. We have employment law, legal updates. There's stuff on litigation, collective bargaining agreements, and unionization. Also stuff for government contractors around affirmative action, EEO1 reporting, and OFCCP updates, as well as anything around disability. You get real-time comprehensive updates for individual states. There's some downloadable HR tools. There's a couple of videos. There's actually a growing video library up there. And there's also case law summaries. The awesome part about this is it's totally affordable. It's only $9 a month. And we offer a 15-day love it or get your money back guarantee. But most importantly is that you actually, in doing this, become my VIP. That means you get the very best of me. We're going to invite you to join a closed Facebook group, of which you will do more the opportunity to go ahead and set up, Q&A sessions. There's a lot more digging into the details. You guys have closer access to me. And that's the great part of it. So if you want to take advantage of that, hop on over to to remember my own website, BrendaTheHRLady.com. That shouldn't be hard. It's my name. And we'll be able to help you get set up and jumping on the bandwagon. Steve, my friend, any thoughts on every time we move forward in this day and age right now, there seems to be more questions than answers. And so we just have to keep working through it all to make sure that everything is going through accordingly. All right, lastly, and then what we'll do is we'll go ahead and open it up to conversation. All right, let's see. May 6th, what we're talking about now is that the Department of Labor actually has withdrawn independent contractor regulations, which has thrown a real wrench into everything, meaning that there's actually more uncertainty for employers. Now, May 6, 2021, the U.S. Department of Labor formally withdrew final regulations that under the prior administration were set forth, and we know that. And for the first time, by the way of an Administrative Procedure Act rulemaking, and the analysis of the department would use to determine whether a worker was an employee or an independent contractor under the FLSA. Now, these regulations clarified that the relevant factors that the Department of Labor would use to determine whether workers are in business for themselves and are independent contractors, or are emphasized or economically dependent, on the punitive employer for work and thus employees under the FLSA. Now, this is coming out of Littler Mendelson. And sorry, I actually have a friend that's standing outside my door trying to text me saying, hey, listen, we're here to say hi. And I'm like, dude, I'm on a podcast right now. Sorry. So that's why we got a lot of barking going on. Now, the final rule emphasized that the proper analysis is whether a worker is dependent on a purported employer for work as opposed to whether a worker is dependent on the income being received, which is really funny because I don't know anybody who doesn't work just, for the fun of it. So the details on these are really interesting. So prior to adopting the final rule, the Department of Labor and most courts considered 7 economic reality factors when analyzing work relationship using the economic reality test. Now, the independent contractor rule clarified the 7 factors by identifying 2 core factors based on an exhaustive analysis of decades of cases dealing with the test. And the first is 1, the nature of the degree of control over the work, and 2, the worker's opportunity for profit or loss. And it's additionally set forth that 3 additional non-exhaustive guidepost factors are to be considered if the core factors are not determinative to a point in different directions. So the third one is the amount of specialized training or skill that is required for the work that the potential employer does not provide, and the degree of permanence of the working relationship, focusing on the continuity and the duration of the relationship, and weighing towards independent contractor status if the relationship is definite in duration or sporadic. Now, whether the work is performed is lastly also part of an integrated unit of production. So it's getting more dodgy. And honestly, here's the thing: when it comes to uh, WHD, which is wage and hour division, that's the enforcement arm of the Department of Labor. This is a huge target for them. All right. The Department of Labor, it's as broad litigation authority under the FLSA. Okay. And unlike private litigation, the Department of Labor can actually expand a complaint driven investigation and any litigation to include as many regions as it deems practical. Now, something that a lot of people didn't know is that when Biden was being sworn in, the Department of Labor, the EEOC, and OSHA were given instructions to increase the number of investigators. So they've been actively hiring. And this is something that they are going to be really, really going out, and they've done a review on their enforcement of the laws and rules. So again, this is something you have to keep your eyes on. Now, you probably have sit there and listened to me say this a couple of times, talk about this subject. Well, the reason why I keep bringing it up is because it keeps coming up. And if something like this keeps coming up, it's really important that you guys keep your eyes on the ball and not misclassify your employees. Yes, you can still use independent contractors. Just make sure that you can substantiate your reason why. Is that if the Department of Labor should come in as a result of this and really targeting the workforce from WHD, right, wage and hour section, not only will they look at every employee, they will look at every transaction time wise, every pay transaction, every time that happened with every employee, and they will go back a maximum of 3 years. And so a full Department of Labor audit actually takes quite a while to go through. I have a client of mine who's been going through one for 2 years now. And that's exactly what they've done. They've looked at everything, going back at every employee, every time clock transaction, every pay transaction that took place for every employee, including the ones that were terminated voluntarily or involuntarily, and they go back 3 years, and it's taken us 2 years to actually work with them directly. So it gets very dodgy. Now, there are ways around, working with government contractors, but if you're in that situation where you need to, government contractors, independent contractors, if you're in that situation where you actually need to consider that, then you really have to do a very stringent analysis and come up with a proper legal strategy, and working with an employment attorney to make sure that you're crossing your I's and dotting your T's. The more directive you are, the more they really are W-2s, right? If it's a service where you can say, okay, this is what I need you to deliver. I need it here done by day, and you walk away from the situation and you're not managing and doing things on a day-to-day basis, well, then that's starting to look a little bit more like, well, it could be an independent contractor. But again, with everything that's changing, err on the side of caution before you start proceeding, and you'll find yourself in a much better position.